So with that in mind, we do have a lot of time for some questions. So let's start with Cleve. And speakers, we'd love to hear your thoughts regarding these questions. So please feel free to jump in. We'd love to hear your thoughts too. Cleve, starting with you. You did start us off with the presentation, so this question is for you. And as I mentioned before, everyone, please do jump in. What is in the proposed new New York law that has Judge Ginsburg so concerned?
Yeah, I hadn't actually been paying attention to New York law. I mean, as an economist, it's not something I would really focus on. And when I went to the ABA spring meetings this year, it was brought up several times. And the law's not passed yet. I understand that the bill has been voted out of committee, and then will go up for votes in the Senate and the Assembly. And I understand it did pass the Senate in New York last year, though not the Assembly. I did run across a pretty good ABA publication summarizing the law. So there were some things in there that were quite interesting. It's a proposal or proposed law that would focus on dominance. So it looks a lot more like the European view of competition. I understand that it would create a presumption of dominance if a firm had a market share of 40%. And then it has a number of activities or legal activities that would be considered unfair pricing as one of them that would be considered illegal. Of course, you can see almost immediately what is unfair pricing. What does that really mean? So it has a very kind of neo-Brandeisian kind of feel to the proposal. I understand that direct evidence of like raising prices would be enough to show a dominant position. So it's not based entirely on market share, and it also appears to eliminate the ability of a firm to appeal to efficiencies for any business practices. So if there's something that is found to be unfair, you can't then turn back around and say, well, here's why I did it, and here's a legitimate business purpose. And non-compete agreements would be considered an abuse as well. And then it explicitly talks about criminal penalties for corporations and for individuals, and including up to 4 years in jail and this would apply to both what we would consider Section 1 and Section 2 abuses, price fixing and any abuse of dominance. So, when you look at something like that and you don't know how, if it comes to pass, how anything like this might be enforced or, play out in the courts or anything. But when you think about some of the aspects of this, the idea that 40% would be considered dominant, that unfair pricing would be considered an abuse of a dominant position, and that if there's an unfair pricing, that someone could face individual criminal charges. And then, of course, there's in there provisions for class action suits and treble damages, et cetera, and no efficiencies defense. I mean, it's pretty certainly uncharted territory. And if it does come to pass in New York, then there'll be clearly a lot of activity and a lot of eyes on New York to see how it unfolds.